All right, well, welcome everybody. Thank you for being here tonight, spending a Tuesday evening with us. My name is Brandon. I'm the Executive Director here at the Pikes Peak Small Business Development Center, where we help businesses grow and scale. We do that through workshops and partnerships in the community, but we also do that through free one-on-one consulting. So last year, our office did around 2,000 hours of free consulting to businesses in the community. We have 14 offices across the state, so you can imagine the impact that our network has across the state of Colorado. So tonight is a partnership with Business Law Group, and we're grateful that they're here writing this curriculum because frankly, it's stuff we all need to know, and probably even us as an SBDC. So we're grateful that you guys given us this opportunity to partner with you for tonight. Now that that's done, you guys get the floor. You guys get the room now, so it's all yours.
So I'm Stacey Rogers. I'm an attorney at Business Law Group. Hopefully you're all in the right space. This looks familiar. You're here to hear about pricing transparency. I see a lot of people who are awake, and my aim is to change that. My goal is to cover these three things. What is the law? What does it mean? Who does it affect? Basic steps on how to stay compliant. And if we have time, we'll go through some of the special rules for particular industries. It's a lot easier to understand what the law does. And I think it's a lot easier to conceptualize what you need to do to comply if you kind of know where the law is coming from. The problem that they were aiming at were those junk fees in residential leases where you'd rent an apartment for $1,200, but then you had to pay the amenities fee and you had to pay a $50 parking fee on top of it. And at the end of the day, now you're paying $2,000 for an apartment when you signed the lease you thought was $1,200. That shows up in other places. We call it also drip pricing. I think we've all run into that, even if we don't rent, where you see service fees, credit card processing fees. Maybe you've booked a room at a hotel and then you have to show up and they tell you it's $50 a day to use the pool. Suddenly a $200 a night hotel is now a $400 a night hotel because it's $50 per person for the amenities fee. Cleaning fees and Airbnbs. Again, convenience fees and processing fees. We will talk more about those. That's what they're aimed at, right? So House Bill 25-1090 is a new Colorado consumer protection law shoved into the already existing Colorado Consumer Protection Act, where they define what unfair and deceptive trade practices are. Signed by the governor this year, aimed at pricing transparency, and specifically was supposed to be aimed at landlords. So you can see this is a screenshot of the actual bill and the legislative declaration saying what the purpose of the bill is. You're going to see that they were aiming at landlords and tenants. But in reality, what did they actually do? What does this bill say? This bill, by its terms, prohibits any person. So anybody is a person. Corporations are people. This is corporate personhood. So any person, any business, any entity, nonprofits, doesn't matter who you are, any person offering, displaying, or advertising pricing information for any good, service, or property. That's the entire economy. That's everybody. That's everything, right? So by its terms, says prohibits anybody from showing a price for anything unless you clearly and conspicuously disclose this maximum total price. And I think my least favorite part about this law is that this total price doesn't actually mean the total price. What else is this House bill? It also addresses some of those concerns that they had with residential landlords and the fees that they were charging. But that, to me, sort of ended up as an afterthought. Again, in terms they were aimed at residential landlords, threw that to the wayside. Who does it actually affect? Everyone. Selling everything. Doesn't matter who you are. The only safe harbors were put in for people who are within a federally regulated pricing transparency law who are in compliance with that federal law. So if you are in a federally regulated industry, but you're breaking that law, guess what? You still have to comply with this law. Safe harbor doesn't apply to you. And then again, you can see there are a few cutouts for industries that are just, they have better lobbyists than the rest of us. And again, it's triggered just by offering, displaying, or advertising pricing information. which I think we can all conceptualize is everything. So again, who is not affected? Federally regulated pricing transparency that's already there. You have to be compliant, for example, with the Truth in Lending Act. So this isn't going to change the way that you see banks display loan terms to you, because they're going to use that TILA format that they're already using. Broadband and cable operators, again, those are regulated by the FCC. As long as they're in compliance with that, we don't really care. Who has special rules or special safe harbors? Food and beverage retail industries. Those are your bars and your restaurants. Those are your brew pubs. Service industry. This was the lawyers. We didn't get the exception that I think we wanted. And I don't think that we were successful in getting the exception for other people in professional services. Title companies, they also have phenomenal lobbyists, as do real estate agents. They got a carve out, probably not as much as they wanted. And delivery network companies, if that makes no sense to you, it's Amazon, it's Grubhub, it's Uber Eats. Who is on their naughty list and got worse rules? The residential landlords. The effective date for all of this, it goes into effect January 1st, 2026. So it clearly applies to any time you offer or advertise pricing information after January 1st, 2026. There's a lot of conflicting opinions out there about whether it would require you to go back and change any relationship that exists right now, for example. There's nothing in the law saying that it's retroactive. I think there will probably be some people litigating this. My caution to anybody who is my client or not, you don't want to be the test case, right? So err on the side of caution. If you have, even if it's an ongoing relationship that is before this January 1st, 2026 effective date, if you can disclose to those people, make the disclosure. Just cover yourself. You're not going to be penalized for doing it. Just because I have an ongoing relationship, maybe it's a situation where people are entering successive orders for something. Well, each time I tell them, yes, I'm going to allow you to make a new order, that's a new act in a new year of offering something for sale. So even though that relationship existed prior, and maybe even it exists with a written contract, that new act in that new year might fall under the law. So I don't care who you are or what you're doing. If you are not accept one of the exemptions, at least on January 1st, 2026, start making these disclosures even to your old customers. Penalties. So this is the why do I care portion, right? Where I scare you into paying attention. The Attorney General can fine you up to $20,000 per incident. That's not per, company. That is every single time you don't do this, they can fine you $20,000. Well, how many transactions does your company have in a year? How many times does your commercial run? Are you advertising to the elderly? Because now it's $50,000 per incident. So again, you don't want to be the test case. There's also a right of private enforcement, meaning your customers can sue you. So they don't have the ability, thankfully, to just sue you outright for $20,000, right? That's the Attorney General. Hopefully their initial enforcement actions aren't that militant about it, but your clients will come, they will sue you as soon as they figure this out. I expect our court system to be absolutely log jammed at the beginning of the next year because nobody's going to be doing this. There has not been enough awareness. What your clients can sue you for is the greater of their actual damages, and then they would earn 8% interest on that, or $500. So say you didn't disclose your credit card processing fee, 2.9% on an $8 beer. Okay, what's their actual damages? Couple bucks. Now that's a $500 problem for you. Also, if you're doing it in bad faith, if it's willful, or if there's fraud involved, you can get triple damages. They also honestly, even more than this $500, we all know how much attorneys cost. You're gonna be paying their attorney's fees when they win. Tenants, this is where that extra, they were on the naughty list, comes in for residential landlords. Residential tenants only, not residential and commercial are typically treated differently. Tenants, residential and commercial tenants both have the ability now to withhold rent, to protest a violation of this law. So what they can do is they can send you a 14-day demand letter. You not only have to stop charging that fee to that person who sent the demand letter, you have to stop charging all of your similarly situated tenants. So one person in a 1,000-person apartment complex can send this letter. That landlord has 14 days to refund all 1,000 tenants, all of the fees that they've collected in violation of this law. If they do not, that tenant earns 18% interest until it is paid. So now that we've all decided that it's clear enough that we care, how do you stay compliant with this, right? What does it actually require that you do? Clearly and conspicuously disclose the total price, which again is not the total price, and the nature and purpose of pricing information that is not part of the total price. When you take these two things together, the total price and the not total price, that's what we would actually call a total price. So let's talk about what the total price is, the way that they define it. That is, the easiest way to think about it is if you're going into Walmart and you're picking up a can of soup, and on the shelf it says $1.50. That should be your total price, right? Is that really the total price? Is that your out the door price? No, we all know we're going to go ring it up and there's going to be, tax before we go out the door. But when they're talking about total price, they mean, does that price tag on the shelf, is that it? It's not really the total price, but it's the total price for that item or for that service as a single number. It's not a price range. That's not going to be compliant. It's not, here's your charge for parts and here's your charge for labor. It's not, the total price you're going to pay is $9.99 a month, but oh, by the way, we have a 6-month minimum subscription. If you have a 6-month minimum subscription, your total price is not $9.99, right? It's $59.94. Okay, that would be your total price here. The other thing, total price is all amounts that a person may pay for the goods, service, or property, not including the government surcharges and shippings. It's sort of just, like I said, that price tag that you would see under that can of soup, that's your total price. We're not expecting you to include sales tax. We're not expecting you to include public improvement fees. We're not expecting you to include shipping costs unless you want to. And as far as including any items which must be paid to purchase, enjoy, or utilize, right? So that's where those extra mandatory fees kind of come in. So if you have an unavoidable fee, it has to be included in your total purchase price, right? Slap that on, put it on the sticker on the shelf. If it's an avoidable fee, you do not include it in the total price. What's an avoidable fee? They have to have an option to buy whatever it is that you're selling without incurring that fee somehow. So say it's a credit card processing charge. If you're not going to include that in your total price, they have to have a way to avoid it. Okay. If you're going to say, hey, tenants at my, residential apartment complex, pay your rent via credit card, it's 2.9%. You have to have a way for their checks to get processed, or you have to accept cash, right? You can't include that fee and then tell them, sorry, it's your choice to pay rent, I guess, right? That doesn't work. There's no hard and fast rule about each individual charge here. It's about whether it's avoidable or unavoidable. So credit card processing surcharges are going to be one that I think trip people up. It's actually both. Those either go in the total price or not, depending on whether you can avoid them. I worked a mock-up of what we're all used to seeing, right? This is now going to be illegal. And the reason is this service fee right here. Nobody knows what that is. This is what they're going to require you to do. Just total it up and put it up here. If it's required and it's part of the cost, We're not gonna add it in a separate line item and then advertise everywhere else that, hey, if you buy one justice from me, it's $30.88. And then tack on service fees that are mandatory when it really ends up being this number. This is the number up here that they are calling the total price. I think anybody off the street, you ask them what a total price is, they're gonna say $52.73 down here. Now we know what the total price is. Let's talk about what's not the total price. That's all that other stuff. These are not part of that total price. But you also have to clearly and conspicuously disclose all of these not total price items. So you got the total price, all of your mandatory fees are included. You then, on all of these other things that get tacked on, have to tell them not just the amount, but clearly and conspicuously have to tell them who those additional fees are going to. So that service charge, who is that going to? Is that going to me? Is it going to the pizza delivery guy? What is that? If I'm going to charge it or it's optional, so for example, shipping fees down here to postal service, I have to disclose where this fee is going. You also have to tell them if it's refundable or not. So this retail delivery fee that we all love paying on all of our Amazon home deliveries, non-refundable after they've delivered it to your house. You can actually see Amazon's already changed their invoicing to show that and disclose that it's non-refundable. Again, just a caution, mandatory fees cannot be added down here at this step. If they're mandatory, they have to be included up here in the total price. Again, our original invoice, what have we done now? This is where it's gotten. What does clearly and conspicuously mean? We probably don't know, so we came up with 8 different factors, and they're all mandatory. So, easily noticeable and understandable. Probably could have stopped there. They got more specific. So, it has to be disclosed in the same means by which the communication making the offer or the sales pitch or the contract, whatever, is presented. So, if it is a verbal offer, then the disclosure has to be made verbally. If it's a written offer, the disclosure has to be made in writing. That's what point 2 says. Point 3, also mandatory, says it has to be all the ways. So if it's a TV commercial that has writing on it and script, the disclosure now has to appear on the TV screen in script and by sound. Every single way your pricing information is disclosed, these disclosures have to be included. Has to be visually distinguishable. So it has to be distinguishable by size, contrast, location, length of time for which it appears, and other characteristics. Keep in mind, other characteristics, also a mandatory factor, even though they don't tell you what it is. So these, again, it has to be distinguishable by all of those. I don't know how, with a written contract, you have something that is distinguishable by the length of time it appears. But I think it's an impossible standard, right? And unless we're digging up Marvin Acme and we're all using disappearing ink for everything other than the pricing disclosure, it's all going to be there for the same amount of time. So again, audible. We have another standard there, delivered at a volume, speed, and cadence sufficient for ordinary persons to easily hear and understand. So this guy, he's illegal. The point of that is the only thing that we hear in that entire commercial is micro machines, right? He says a lot of other words. That entire sales pitch, totally legal. Here's one that's going to affect everybody who does like Right Signature or DocuSign. If you present your pricing information or your contracts to people through interactive electronic medium. So I took a screenshot of actually our software that we use with clients. It's called Right Signature. DocuSign has a similar button. You open the document, you click on this. It scrolls through the entire document at lightning speed, right down to the signature line for you. Can't do that if it scrolls them past your pricing disclosures. Has to be unavoidable. So if you put it to them in a position where they can flip past it, nope. We've all seen these. Check the box. That's not good enough either. Because see this link? You have to actually click on this link to see any of the terms and conditions and the disclosures. You can check this box without ever opening this link. It's avoidable. So we all now, all of us have to be that irritating software where you have to open the terms and conditions and pretend that you read them before you check the box. Here's another one of my favorites, using diction and syntax understandable to ordinary persons. So ordinary persons, the average person in the United States reads like a 7th or 8th grade level. It's also required to be in every language in which your pricing information appears. Now, if you present things in multiple languages, make sure your disclosures are also sufficient in all of those languages. The disclosure must not be contraindicated or mitigated or inconsistent with anything else in the disclosure. And then again, comply with this for every single medium through which it's received, including electronic devices and face-to-face communications. So how many people have a verbal conversation with a prospective customer and then maybe email them? Yeah, both times you have to make these disclosures anytime there's pricing information. So if you have people answering the phone and then giving out maybe soft bids, you better train them. So now we know we have to clearly and conspicuously disclose both the total price and all of those things that's not the total price. But total price must be disclosed more prominently than any other pricing information. Literal application of more prominent is going to increase people's confusion because this is the total price. Remember, this is what the law says has to be displayed more prominently than any other pricing information. If I were going out in the world and creating invoices, I would not do the thing that I showed on the last slide that I think is a literal application of more prominent, because there's still the requirement that you not mislead people, okay? And if you tone it down a little bit, technically this is still larger font. It's technically more prominent because it's larger font, but I think not so much more prominent maybe makes it blend more and is less misleading and less confusing to people. So there's no hard and fast rule on that because the more prominent doesn't have 8 distinguishable factors like the clear and conspicuous. So what do you actually need to do? First, figure out whether your industry is one of the industries that's covered by the law or is exempt. Figure out if you're under one of the exemptions or whether you have one of those special rule safe harbors that is frankly an easier playing field to play on. Then you're going to want to get that disclosure together, update all your materials, your bid sheets, your contracts, your restaurant menus, all of your advertising, all of your social media. You know, if you post something on Facebook that says, hey, we've got a special this week and here's the price, well, you better make sure that all of that pricing information is included in the post. You also probably want to update your point of sale system because it's going to need to display those things to people again, technically before the transaction is finalized. And then you're going to want to train your staff. Like I said, I would recommend if you have people answering the phone and talking to people about pricing information, give them a script. Make it easy on them because you're the ones who are going to be paying the fees. I also, in 15 years of supervising staff, if I update a form or a procedure and I don't remove access to the old one, somehow I end up seeing that document again. So my recommendation, this isn't a legal recommendation, it's just a practical one, is to remove access to the non-compliant material. So just get rid of it, make it so that your staff can't accidentally pull up the wrong form, pull up the wrong phone script, and cause you a problem. DocuSign practices or electronic signature practices. Revise these forms so that your signature page is next to the pricing information. Because again, it has to be unavoidable, right? So if you're any electronic signature software has that function to just skip right down to it. So you're either gonna have to insert an initial on that page with the pricing information every single time, change your form so that the signature that they have to sign is next to the pricing information so that it's unavoidable. So special rules, restaurants, they got that special safe haven rule. If you're listening and you're thinking, well, how do restaurants do this? Because they're going to have mandatory service charges for large parties, right? And that's not going to be, they're not going to have a special menu that they hand out to people for large parties versus small parties. They got an exemption where all they have to do is show the percentage of any mandatory service charge and an accurate description of how it is distributed. So somewhere on the menu, alongside all of your other pricing information, can't just be on, the bill after everybody's ordered, has to be up front, clear and conspicuous, can't be super tiny down in the corner. Tell people what your mandatory service charge is and whether it just goes to your waiter, whether it's split with the kitchen and whatever. If you do that as a restaurant, bar, whatever, you'll be okay. But again, it has to be upfront on the menu, readable, cannot be just on the receipt later. Same with credit card surcharges. So any mandatory fees, put it on the menu. You're going to be reprinting a lot of menus, I think. Service industries. If you're selling a service, how do you price that up front, right? It depends, is the answer every single time. I don't know how much it's going to cost. I call an HVAC guy. I don't expect him to have a to the penny number before he's even gone to, and looked. So there is an exception where you're selling a service, but it has to be a situation where you cannot reasonably know the total price at the time of the offer. So there has to be some kind of variable involved, and you have to identify what those variables are. So some of the examples that they give you are maybe consumer selections. So I might buy a tankless water heater to replace my old one, right? That's my choice. You're not selling me that. You're not making that choice for me. So that's a consumer selection option that's going to change my total price. Then you can't reasonably know what my selection is going to be the first time I call your shop, right? So you can tell me, I don't know what the total price is going to be. Maybe distance, if you're charging somebody mileage, time, especially with labor fees, time, you don't know how long it's going to take because you haven't seen the problem yet. Hidden or latent defects, sure, I can sell you a carburetor, but I don't, know everything else I'm going to have to sell you until I take it apart. And these things are industry specific. So these examples are common ones. You're going to know what the things are that cause your price to vary in your service industry. So you still have to include any mandatory fees. You have to include a warning that the total price might vary. And you have to include a warning about what factors go into determining that total price. So you're not off the hook, really. You just get to tell people, here are all of the things I'm going to use to determine your total price. And that has to be clear and conspicuous. Again, every single time you touch that customer with pricing information before they agree to pay you. An example, so these are blank for a reason. The total price for whatever services cannot reasonably be determined, but I'm going to tell you what the hourly fees are. I'm going to tell you the total price will vary because that's a legally required element. And I'm going to tell you why that total price is going to vary. I'm not just going to say based on time spent and end there. The reason is the time spent, that's largely within my control as the person selling the good, right? Or selling a service. Unless there's something else controlling how much time I spend. So you're going to want to list not just the time spent on the labor charges, but you're going to list whatever it is in your industry causes time to go up or down. So it might be the complexity of the matter. For us, are you in litigation? How big of a jerk is opposing counsel? Those things for us change how much time we spend on something. So here's a lengthier one that includes some language about, okay, we're going to add an overhead fee on top of the cost of materials because situations like yours where you're going to have, I'm going to go out and buy parts. You're going to charge overhead on those. You're going to add your overhead and profit. If you don't disclose that, you probably don't get to charge your overhead fee on your materials that you go out and buy. So again, if you're charging materials plus your markup, right? So if you're saying, hey, I don't know what materials I need, but I'm going to go out and buy stuff plus 10%. If that's your pricing structure, then you're going to tell people that, right? Because I don't know right now what materials I need. If you're doing a job where you know I need 5 widgets, then price it for 5 widgets, put it in the total price. Nobody cares, nobody knows. But this is for cost plus type jobs. That yes, you would have to tell them the percentage you're going to charge. And keep in mind that other pricing information that we're disclosing here, you have to tell where that's going to go to. So on purpose, this says we will collect a 10% overhead fee on materials we provide, meaning it's coming to us. We're not giving it to Home Depot or the lumberyard, right? That's me. I'm keeping it. I'm keeping that 10% because I am required to tell you where that additional cost is going. I also have some language in here, each trip will incur a minimum $75 charge for labor. Maybe it's more than that, maybe it's less. But if you have something like that where it is going to be a trip charge and your disclosure here is only talking about hourly fees and you spend 5 minutes at that property, you get to charge for 5 minutes because you didn't disclose your $75 minimum. Then when we're talking down at the bottom about total price will vary depending on time spent, materials needed, trips made, right? Maybe you make 5 trips, maybe you make 2 trips. Each one's a $75 charge. Title companies and settlement agencies got some special rules. Real estate commissions, so broker commissions, are not exempt. So if you're going to sell your house and you're signing a listing agreement and they say, hey, I'm going to charge you 6% or 5%, then they put a listing agreement in front of you that says you also have to pay a $295 administrative fee or a closing coordination fee. Those are junk fees. You don't have to pay them. Real estate agents are part of the problem here. The title companies and settlement agents are exempt because they're the ones balancing figures and tax prorations, and those numbers are shifting all over the place. They're exempt for anything that is actually a settlement fee. But your real estate agents are not. If they did not disclose the fee to you as a single number right up front, you don't have to pay it. Residential landlords, I'm not aware of really any residential leases where people were charging property taxes and common area maintenance fees straight through to their residential tenants. I see that a lot in commercial leasing. I do a lot of commercial leasing, but you are not allowed to say, hey, it's $1,200 a month in rent, but also you're going to pay property taxes and common area maintenance. For residential leases anymore, you can't do that. You're also not allowed to charge them those payment processing fees. Again, unless one free option is reasonably available. So that was happening a lot where these, big apartment complexes were saying you have to pay your rent online. And by the way, the only way to pay your rent online is by credit card and there's 2.9% fee. They can't do that anymore. You can't charge late fees on non-rent payments. So utilities that the landlord's paying and you're reimbursing, that's not rent. You can't charge your tenants a late fee on your utilities anymore. Anything else like that that's not rent, you don't get to charge a late fee to your residential tenants anymore. So again, rent, probably going to go up. Fees for fulfilling your legal duties. This one I think I have seen. So if you're doing pest control, you don't get to charge that through to your residential tenants anymore. Even if it's a service that they caused or were needed, you're maintaining habitability. That's your legal duty as a landlord to make sure that that building is habitable. You don't get to charge those fees through to your residential tenants anymore. So again, that would be a good example of that ongoing relationship where I'm saying, I think you really ought to just make the disclosures in January, even if you have a relationship, even if you've charged this person before, let's make a variable price disclosure to them. Residential landlords also cannot any longer charge markups on services billed to a landlord by a third party, including utilities, unless it's in the lease. So hopefully they can all get new leases before January 1st. And then there's caps on that also. Any other fees can't increase by more than 2% over the course of the year. So it's not technically a rent cap, that's in a different law, but we have so many new regulations for residential tenants that I don't think people are keeping up. So again, all landlords now, not just residential landlords, your tenants are going to have this private right of enforcement and this 14-day, here's my demand and fix it. I think most of the big dollar enforcement is gonna happen at the Attorney General level because they have the ability to fine that $20,000 per occurrence. And everybody else is gonna be limited to actual damages or the $500, right? This is gonna be the exception to that because the tenants are gonna be asserting this right on gamut fees, right? That's tens of thousands of dollars in a year if you have a big enough commercial space, right? I don't wanna pay it. It's worth litigating. Back to residential landlords. I listed here just from 2024 and 2023, all of the other major changes or some of the other major changes. I ran out of space. If you are a residential landlord and you are not keeping up with any of this, you're asking for trouble. Because this piece of this law that outlaws all of those fees is really a follow-up to some of the things that they just didn't get squeezed into these other laws. If you don't know these already and you are a residential landlord, hire a professional property manager who has adequate insurance because there's no way you're doing it right. You're gonna have an illegal lease and you're gonna pay for it. So unless, like I said, you have kept on top of all of those things, frankly, the cost to hire a manager who has that insurance is probably worth it at this point. So that is all I have. I'm sorry I ruined your day. Do you have questions?